I'll hand over to you. Thank you, William.
So, hello everyone, my name is William, just by way of a brief introduction. So, in terms of what I do, I am a civil engineer by background, and I've since cross-qualified as a solicitor, so construction guy that does the law effectively. So, hopefully fairly well placed to talk you through dispute resolution here today. The other thing about me, I am a practicing adjudicator, so I'm on the ICE panel of adjudicators. I've made a number of decisions in recent months, all under NEC, so hopefully we'll be able to lean on that experience as well to talk about what exactly I see as an adjudicator from a dispute resolution perspective. The point of today is to do myself and Brian and everybody else out of the job, because dispute resolution and disputes, you need to avoid them like the plague. Disputes are costly endeavours that benefit absolutely no one in the process, apart from us lawyers, okay? So that's the overarching point that I want to make today. If you can, avoid it like the plague, and that's the best way to remember it. So in terms of how I'm going to tell this story, we're going to start by looking at the various different causes of disputes within the UK construction industry. And we're going to tee that up with a little bit of a show of hands using our red and green cards, just to set the scene a little bit to understand why exactly this is so important. So if you get those cards at the ready. I'm going to then frame that discussion by looking at some of the recent statistics published by King's College London in conjunction with the Adjudication Society that looked into, the state of adjudication here in the UK. Adjudication being the premier way of getting disputes resolved, at least from a third-party perspective. We'll touch on resolving disputes, and then ultimately this will hit us home to understanding what we can do better as an industry. And as I said at the start, avoiding it is the key to all of that. Prevention is certainly better than cure. So I drafted these slides a week ago, so I appreciate that talking about red cards to an English audience, rugby fans, might be a little bit touchy. I did, and it's in my little notes here, make a joke about red cards from the Six Nations. So thankfully England capitalised on that at least. So what I'd like you to do is get your red cards ready and put your red card up if you have ever been involved in a dispute over one or any of the following topics. The quality of works delivered on the site. So arguments over whether or not completion, clause 11.22 of the NEC, whether or not that state of affairs has been achieved. There's a few up at the back. Whether or not practical completion has been achieved. Keep the cards up, please. Keep the cards up. Next one, the valuation of payment. So let's bring in the payment disputes here. Whether or not a pay less notice has been issued, as we touched on this morning, whether or not you've validly issued an application for payment, or whether or not you dispute what's actually been assessed. Extensions of time or associated disputes, lots more going up there. So how much time you actually are due as a result of the problem. Again, NEC is famous for having that programme to assess extensions of time, changes to the planned completion date. Ambiguous contracts documents. You mentioned an acronym earlier, VULGAR. VUCA. What was it? Vulgar.
Volatile, uncertain, complex, and ambiguous.
So that point, anybody ever been exposed to one of those? And last but not least, poor contract administration. So if you've been exposed to any of those, please do put your red cards up. For people tuning in online, I'd say at least 95% of the audience have a red card up at this point. So what is the takeaway from all of that? Disputes are common, folks. Everybody, at least 95% of this room, has been involved in a dispute at some point in time. So why is that? Well, what we do in construction is bloody complicated. We're not building with Lego bricks here. We're bringing in lots of different stakeholders from various different parts of the country, from overseas, internationally. It's uncertain. So again, any long linear road scheme, you're going to have boreholes at set centres. You don't know exactly what the ground's going to be like at every single infinitesimally small point in time or point in space. Contractual relationships, we have plenty of different subcontractors, suppliers being brought in from all levels of the supply chain. They all have competing interests. They might have a legal team drafting and to design to make these documents as difficult as possible to deal with. They might not have legal representation and might not understand what they're signing up to. Human behaviour, which is more of a pervasive point that encircles all of this. If you have one person in the room that does not want to do a deal, you're going to get to a dispute at some point. We need to change that behaviour and we need to start moving things away from that. So for all of those reasons, that is why the red cards were going up in the room, and ultimately that is why we understand that disputes are so common. The other and final analogy I want to make just with the red card, When I was watching that Ireland-England game at the weekend, sorry to dwell on it, but I am an Irishman. The analogy struck me that the decision of a referee is quite like the decision of an adjudicator. You need to think rapidly. 9 times out of 10, you're going to have something like 7 to 14 days to make your decision once you have received all of the papers, that is. It's a very short and intense process. And I'm an Irishman, I thought the referee got it wrong. So what does that say about adjudication? Because you're trying to make a decision in such a condensed time frame, you don't know what way they're going to go. They need to make a decision quickly, so therefore it's within your interests to don't give it to them, to make that decision between yourselves, to try to arrive at a conclusion without giving it over to a third party. We'll come back to that point shortly. So much you can read into a rugby game these days.
Yeah, well, he was a Scotsman. I thought the referee was spot on.
We'll say no more. I was speaking to a few Welsh gentlemen earlier. We'll say nothing about the Welsh rugby either. So, takeaway number 1. Disputes are commonplace in the construction industry. We all had the red cards up. We all know what's going to happen. So what does that say? We need to go into any project with our eyes open. We need to take a proactive approach to resolving disputes, not a reactive approach, which in my experience, as an adjudicator and party representative, that's what people do. So we need to start moving in a different direction towards that proactive approach. So to ground some of this in some recent statistics, I'm going to focus on a paper that was published by King's College London in conjunction with the Adjudication Society. If you type into Google King's College Adjudication Report, you'll find it, but I'll provide a link as well within the materials. This report does what it says on the tin. It focuses on adjudication in the construction industry. And as I said before, this is the go-to means of getting disputes resolved here in the UK, at least via third-party intervention. There's nothing to stop you resolving disputes between yourselves, but this is normally the starting point when it comes to bringing in a third party. And under the likes of the NEC, this is the mandatory starting point. You need to go to adjudication before you take it to the tribunal, unless you've went in and amended that. And there's been some recent cases on that recently, as I'm sure you're all aware of. So what this particular report identified is a number of leading causes of disputes, and I'm going to focus in on that in a bit of detail to look at what the top 10 causes of disputes are here in the UK. And then we're going to take a look at how we could potentially move things away from that. The other end of the spectrum here, we've got the carrot approach, where everybody benefits from moving away from an adversarial industry. And we've also got the stick approach, whereby if you don't, you're going to have to pay big money. You're going to have to pay for your representation. You're going to have to roll the dice on the adjudicator, potentially getting it wrong, the referee making the wrong decision, that analogy. And also the internal resource drain that adjudication and disputes has internally. The amount of time your managing director is going to be away from their desk, the amount of time that the boots on the ground are not focusing on proper work. I say proper, actually working to advance the works on site. They're taken away and they're working on witness statements. That benefits no one apart from the lawyers at the front here. So again, we're going to frame what we're talking about with reference to these statistics. So I'll let you just digest that. Take a very quick gander through the top 10 reported causes of disputes in the UK. Give me a slight refreshment as well. I read that and I was slightly shocked. The first one, inadequate contract administration. That's the leading cause, the leading reported cause of disputes that get to adjudication. What is that cause? Is it avoidable? Absolutely it is. By investing in proper contract administration, fast draft, or the other one, as we keep saying, by making sure that your staff are trained from the outset, both client side and contractor side, you can avoid that completely. 49%, almost half of the 257 respondents reported that as being the leading cause of disputes. I think that's shocking, to be honest. Changes by the client, that one's a little bit more difficult, doesn't really say what that means. Changes by the client shouldn't be adversarial if it is administered correctly. So I actually think that one leads directly into the point above. Change in itself shouldn't be contentious. That's not a cause of disputes. It's it not being implemented correctly. Implemented correctly is the problem. Exaggerated claims, again, this fourth one, a lack of competence in the project participants. That is wholly avoidable, in my humble humble opinion. By properly investing in training, doing what you're doing all here, the CPD events, going to the PM accredited courses and all of that, that can be avoided to an extent. Unclear risk allocation, inadequate contract documentation, ambiguities, discrepancies, divergences, whatever adjective you want to put against that, not getting the contract documents right. Again, in my opinion, wholly avoidable if you spend a little bit more time and effort getting it right at the outset, which I think is a theme emerging from all of the talks that you've heard here this morning. Spending a little bit more time and effort up front will pay dividends into the future. Think of it as an investment. So what I've done, I've just had a look at all of those, and I do think that the majority are avoidable. If you spend a little bit more time and actually dedicate proper resources at the outset to avoiding them. So that's the next takeaway that we're going to consider here. That disputes, to an extent, even though they're very common, they can be avoided with proper preparation. That's my opinion anyway. And we'll touch on that a little bit later on, and we'll understand what we mean a bit more by that. So the third strand of what I want to look at is, the opposite side of this. What do you get if you end up in adjudication or some other form of adversarial dispute resolution? So what we've got here are a number of statistics that deal with the claim values that go to adjudication. So you can see the most common one is disputes in the region of 125k up to £500,000. At that point in time, you're going to need to be expending significant fees for representation in that process. You're not going to want to go into that with your eyes shut, effectively. You want to go in armed as best as possible to come out with the best result you can. What I also read into that particular statistics, as you get further to the left-hand side of that diagram, there's less and less disputes in and around the 50 to 25k mark. So if you're getting to disputes of that level, adjudication's not really going to be there to help you, because the amount of money that you have to spend to get a result, you're not going to potentially get that back. It's not a commercial thing to do at that point. So there's plenty you can read into with that statistic. The other one is the adjudicator's fees, which in my opinion are starting to spiral in the wrong direction. So if anybody's been involved in an adjudication recently, I'm sure you would potentially agree with that. So as you can see here, the most common fee, sort of bracket charged by an adjudicator, is something between 8 and 20k. And that would align with my empirical evidence gathering over the years as well. We've got some adjudications upwards of 50 grand of adjudicators' fees. That's shocking. I've never seen fees as high as that personally. I have seen fees as high as 30k in my experience, and these fees are starting to eclipse the values involved in the adjudication itself. And the point is, this is another unnecessary expense. If you spent that 30k paying John to come in and there you go, John, setting up your project correctly from the outset, 10%. Setting up your project correctly from the outset, investing in workshops to collaborate with one another, spending time thinking about the strategy. Is that money better spent? Absolutely. This is only the adjudicator's costs. This is only the tip of the iceberg, because you've got all of these other factors and things that are not encompassed within the statistics. The irrecoverable legal costs. So in adjudication, if you spend 20k on a lawyer, you don't get that back. It's a write-off effectively. So we're up to potentially 50k. John? Yeah, another 10% there. As I say, the more time and effort you can spend avoiding these problems, it's money better spent. The inherent uncertainty. People have described adjudication and adversarial forms of dispute resolution as an expensive way to flip the dice. And it is. I have seen cases that I thought were bang to rights, and the adjudicator just goes off on a tangent of their own. The opposite is true. If you're up against it and say you're arguing that a pay less notice is valid when you really think it's probably not, and they've agreed with you. So again, it can work both ways. It's a double-edged sword. Point is, it's inherently uncertain, and that is not something you want to do. You want to avoid uncertainty as best as possible. And you can do that by keeping the disputes between yourselves, mediation, negotiation, and the point that I'm trying to make, by avoiding them altogether, by spending more money up front. The irreparable commercial relationship is a nuclear button. Once you push the button into an adversarial form of dispute resolution, the chances of ever working with that party again are diminished. Again, at least in the English market anyway, I find that that's the case. The fourth bullet point there, I think, is a very important one, so just consider that for a second. You might want to think of this as the hidden cost of the likes of adjudication or any other dispute resolution process. And this is not the cost that you pay the legal team or potentially pay the adjudicator or your experts. This is the key resources being sucked into the process. Has anybody ever been involved in that? Hands up. You know, you've had to draft witness statements. You know, you probably understand what I mean by this. The time that you spend doing that would be far better spent doing something productive. Absolutely. You can't quite put a monetary value on it, at least not as objectively as your legal fees, but trust me, it's a key part in the process that has to be considered. Sleepless nights for directors and shareholders. Has anybody ever woken up in the middle of the night thinking about work? Hands up. There you go. The fact that you're all sitting here, there's probably a bit of a survivorship bias. The fact that everybody here has thought that doesn't surprise me. And I can only imagine what my clients think, you know, rolling the dice in an adjudication. I lose sleep over it as their representative. Shows how much I care in the sales pitch. But I can't imagine what they face, their business potentially being on the line. If this adjudicator goes off on a frolic of their own, their business is under. So that's a very significant point to consider, and it's another intangible, hidden cost of any dispute resolution process. The point is, avoid that like the plague. Make your life easier by investing and preparing up front. So the third and final takeaway is resolving disputes is expensive, both in terms of the upfront legal costs, the exposure to the adjudicator's fees, but also to that internal resource drain, to those hidden costs involved in the process. So all of that collectively, let's look at those takeaways, I think tells the same story. Takeaway one, disputes are common. We all know they're going to happen. So therefore, avoid them. There's an incentive there to avoid disputes because if you avoid them, you avoid having to pay out all of those costly fees. There's a feedback incentive mechanism there. And similarly, because resolving disputes is expensive, that's a further incentive to try to avoid them. So all of this goes to the same point, that preparation is better than cure. I'm here today to talk about driving change in dispute resolution. I'm not really talking about dispute resolution itself. I'm talking about driving change, how to avoid disputes, and that's the key takeaway, that preventing them is better than curing them for everybody in the room apart from us three at the front. Okay, so practical tips, or before we get to the practical tips, let's just maybe draw a contrast between what we do in construction to what other industries do. So in my experience and in my opinion, we are a reactive industry. Project teams very rarely work with one another on more than one project. You come on, you'll do a good job and you'll move away onto the next project. And the likelihood of you ever working with the exact same team again, with the exact same suppliers, stakeholders, funders, banks, whatever it happens to be, is actually quite small. And for that reason, any lessons that you learn on that project don't typically get fed into the next one. There's a knowledge problem there, a knowledge retention problem. Where if you compare that to the likes of the aviation industry, if a Boeing 777, what was it, the Supermax airplanes, remember those from a few years ago? There was an inherent problem. All of the airlines in the industry stood together to figure out what was happening. They are a proactive industry. We just don't do that for various different reasons. I think we need to start learning some lessons from the likes of the aviation industry to stop pointing fingers and to start working together. That takes me back to the same point that prevention is better than cure. So in terms of, we've come quite a long way here, what are the practical ways to actually prevent disputes then and to put this into practice? So this first one, I've got a very silly little slide there. It's called an early collaboration workshop. And I was involved in one of these about 5 years ago for a project down in Kent. It was a new primary school project, and the employer on that project was phenomenal. They bought into the whole prevention is better than cure process, and they drove the whole process from the top down. We had this early collaboration workshop, which was driven by the employer, requested by them, where we had the lawyers in the room, QSs in the room, project manager, contractor, and key subcontractors, and obviously the employer themselves. And the employer got up and played this video from YouTube. If you type into YouTube, Guy Starts Dance Party, you'll find it. And it starts with this gentleman, having a whale of a time at some music festival somewhere in Canada. And he's just dancing there for a couple of seconds and he looks like an idiot. But very quickly, people start to latch on to that idea. And by 2 or 3 minutes into the video, every single person in the festival is having a whale of a time. This stuck with me, genuinely did make an impression. That's the client here. They are the person looking like an idiot, doing what the whole industry is not doing, driving collaboration, but eventually everyone will start to move in the same direction. Momentum has to start somewhere. It's not created out of nothing. So that was a takeaway from me. So what I'd advise, if there are any client organizations in the room, hands up, be that idiot. Be that person that is dancing, be the person that leads the process, and start to bring your supply chain in with you and collaborate from an early point. If you set things up for being adversarial from the outset, it's going to end up that way. You're going to end up in a boxing match. Similarly, the likes of a dispute avoidance charter. Again, this is slightly woolly stuff. I do appreciate that. It's hard to enforce all of this. But bringing everybody into the same space and making sure you all understand the problems and the risks from the outset. It can be done at that collaboration meeting as well. Making sure that you're all pulling in the same direction. It's the same point. Invest heavily in contract administration. So as we saw with the statistics from King's, the leading cause of disputes is inadequate contract administration. The second most prevalent cause is change implementation, which is the same thing. So the two leading causes of disputes revolve around that very straightforward point. If you can bring in staff that understand what they are doing in your procurement process, vetting their experience, NEC, clause 24, key people, making sure that if you're being promised the A team that you're not getting the B team, making sure that those individuals are all singing the same tune is an absolute cornerstone of all of this. If you don't get that right, the house of cards could potentially tumble. Nip issues in the bud early. Again, avoid adjudication like the plague. I keep saying that. I'm an adjudicator. I want you to avoid going to adjudication by using the senior representatives, naming them people that are commercially sensible within your business, people that have been through the dispute resolution procedure before, have had the sleepless nights. They are the people that you want named as your senior representatives, because they are the people that realize no one wins in this process apart from the lawyers. Dispute resolution boards, slightly more formalized version of that. So again, actually naming a third party potentially to come to the project, dealing with how they're going to be paid up front. All of this is subject to Section 108 of the Housing Grants Act that you can adjudicate at any time. We can't get out of that, but by understanding the importance of having both of those things, you understand that it might not be the best solution. Or alternatively, mediate or conciliate, negotiate if you can. And then finally, all of this requires client investment up front, but the way you have to think of it is not wasting money, not wasting cash, it's an investment. One extra unit of effort spent trying to avoid disputes will save you 10 units of effort if it ever gets to that point. And that's ultimately the takeaway from this entire presentation. So that's me. Not sure where we're at timing-wise, probably slightly early. But we're going to take a short break at this point just before I go into the emergency presentation that I happen to have prepared. You never know. So we'll take maybe 5 minutes now, Chris, and we'll start back.
Do you want to take questions from the audience?
Absolutely. Any questions before we do that?
So, as a client organisation, if you're in a competitive procurement type scenario, and especially if the market's tight, then a potential contractor might have seen a weakness in the documents.
Mm-hmm.
Despite you might have engaged the best lawyers, but they might think, oh, there's this angle on it. How do you How do you ensure that you've got that proactive engagement from the contractor at the start in that sort of scenario? I mean, I have to say that we put a lot of effort into trying to negotiate by best value, procure by best value, as I'm sure all the clients in the room would do, but you can still get that sort of scenario.
I'm going to maybe flip that question on its head, because what typically happens is client organisations rely upon these order of priority clause or precedence clauses because they don't spend the time getting the documents right, and they try to rely upon that. As we all know, that will then lead to problems. But by the sounds of things, the Environment Agency understands this message, and they're trying to not rely upon that by investing up front and getting the documents correct. So you're going in the right way, but to try and avoid it, it's actually quite difficult beyond that point, because the market is entitled to identify opportunities and to capitalise on them. So if you do think that there is propensity for that to happen, maybe the likes of early contractor involvement, bringing them in at an earlier stage to try to iron out those potential wrinkles within the works information or scope is maybe the other thing that you can do. But by the sounds of things, you're already going quite far in the right direction.
Yeah, can I just add to that as well, as a client organisation as well, as part of our tender process and some of our big programmes, we actually ask for collaboration as part of our evaluation process.
Yep.
There's things in ISO standard. We take it very seriously. How well does this company that we're looking at fit with our culture of our organisation? Where have they collaborated in the past? Has it worked? What are the issues? And it's a big part of the overall selection process.
I've seen that before with, as part of the procurement process, actually having interviews and behavioural analysis as part of that. That's absolutely, it's a further step. Not every client organisation, I would say 99% of them don't take that extra step. So listen to this guy. Thank you. Yep.
What's your view on mediation in terms of What's your view on mediation in terms of it's a little bit easier to do and you can influence the outcome a bit more with the mediator, and it's something clients are looking at more and putting in contracts. Do you think it promotes disputes more than, as you've pointed out, the adjudication process? It is expensive and flipping the coin. I know as a client we want to go towards mediation more, but when we're concerned it almost promotes a dispute. But just what's a view?
Yeah, I think the message is the same. You know, once you have a dispute crystallised, the options available at that point is a slightly different question. I don't necessarily think it promotes disputes, but I would be a massive advocate of mediation as the first step in the process. But that's not to say that you shouldn't be doing all of this to try and avoid them in the first instance. If you can avoid them in the first instance, not only is the likelihood of an adjudication going to go down, but the likelihood and the complexity and the time involved in a mediation should also go down as well, if that answers your question.
It's just a debate whether you actually put it as a contractual requirement into the contract. Does it promote it? Is it good or bad? Just a few.
Yeah, I suppose the short answer is it could promote it, but is that necessarily a bad thing? Because at that point you are resolving the disputes between yourselves, which is the intention in all of this. So if it did promote disputes, which I'm not too sure if it would, I don't necessarily think that would be a bad thing, because it's bringing everybody to the table, and that is the whole point of this. If you can resolve it between yourselves, that's the best way to do it.
Do you see the industry moving in that direction more with mediation?
I do. I do, quite frankly. The UK recently joined the Singapore Mediation Charter in the last couple of weeks or so. So I do think that the UK is moving towards pushing people in the direction of mediation. And again, the likes of the CPR rules, if you're going to court and whatnot, requires mediation as that initial step. If you don't do that, there are repercussions. But obviously adjudication is slightly different to that. But I do think as a general trend, we are going in the direction of mediation. And rightly so. Brian?
I mean, as a comment on the collaboration workshops. This is, I mean, we've been using this for several years, certainly on the bigger procurements that we actually do. And I think the main reason is sometimes we get a contract which the commercial teams have been negotiating, and you need that stopgap when it actually goes over to the delivery team to make sure, you know, the commercial negotiation has now ended, now we're into the delivery phase. And I think holding those workshops we found absolutely invaluable. And another point is sometimes you can then see if there are any problems at the delivery stage between certain individuals, for example. So you hold a workshop. We found that absolutely invaluable, just as a comment. So.
Absolutely. Again, I've worked for and with main contractors for most of my career, and most of their structures are geared towards having an estimating team, commercial team, and then a separate, totally separate delivery team. And if those two teams aren't talking internally, that's also going to lead to problems. And having both of those, both, you know, an internal handover and also an external handover in conjunction with the client, is good for everyone.
Yeah, I'm going to reiterate about the costs that you mentioned there, William. The last big dispute that I was involved with, I mean, I think we ended up with about something like 6 adjudications. And this is going back probably 10 years or so. And each of those adjudications were costing £15,000 to £20,000 a time without really moving things very much forward. We didn't have mediation in the contract originally. It went for mediation. I think that actually it didn't solve it initially, but what it did do, it did move things. It kind of broke the cycle to get
Yeah.
people to sit down and talk about things in terms of, and just to reiterate those additional costs, you know, this went on, and so the distraction, you're in the middle of a big project over 5 years, you're halfway, you know, you're kind of 2 or 3 years in to it, people are focused on, you know, not delivering the project. There was a lot of time and energy going into, as you say, the statements of case, all those things, the distraction. We had a whole separate team, as big as the team delivering the work, actually dealing with that. And you're spending, you know, for 2 years after the job finished, both the client and the contractor are spending £1 million a month just on legal fees.
It's called the sunken cost fallacy. People have invested so much money in the dispute resolution process, they can't see the escape route. Commercially, you just need to look at it black and white. What's it going to cost me to get out of this? That's normally the first question my slightly more sophisticated clients would say, to put it politically correctly. They would say, how much is it going to cost me to get out of this? And that's the best way to think of it. Commercial always wins.
Any more questions for William? Thank you very much, William.
Yep, thank you.